Hi there, how are you doing? My name is Mutiaba Conrad. I'm a lawyer and I'm also a private law tutor. And basically, today we are going to be looking at another interesting topic, and that is the topic of duress and undue influence. However, before we start on our class, I encourage you to subscribe, to like and share my channel, and also ensure that you turn on the notification so that you're always able to get a message whenever new classes are released. Also, very importantly, is that students who are interested in private law tutorial sessions with an expert for proper mentorship, proper guidance, you can always contact us. Our number is down in the description box. And I have always really insisted and encouraged that students should really be part of these programs. We have seen many people being part of these programs, and they have really drastically changed their grades. So this mentorship, this professional touch really privately with experts really helps, and it will really help you to increase to greatly improve your grades. So let's start right away by looking at our topic of undue influence and duress. So basically, under duress, in this video, we are going to be looking at the definition. We will look at the law. We'll also look at what doesn't amount to duress under the law, and also the various forms of duress, which will, of course, include economic duress. And then finally, we'll look at the conditions for establishing duress. Then, when we look at undue influence, we'll be looking at the definition, the positions that we'll also be looking at the positions that put a person in dominance as to have undue influence over others. We'll also proceed to look at the classes of undue influence, of course, which include actual, presumed, undue influence, and then also relationships of trust and confidence. We'll also be looking at those. And then finally, we'll also look at how to prove that there was actually no undue influence. So having laid out properly how we are going to proceed, let's start right away with looking at duress. And we are going to start by defining what duress actually is. So now, here when we talk of duress, what we mean is actual or threats of violence to a contracting party. But however, those threats of violence must be calculated to produce fear or loss of life or even bodily harm. So here what we're trying to say is that the moment someone makes certain threats, okay, of maybe to inflict fear or to inflict bodily injury, and that is their main purpose, okay, of persuading you to actually enter contract, then the same under the law would amount to duress. Let's now proceed and look at what the law defines duress is. When you look under the Contracts Act 2010, the law refers to duress as coercion, okay? And when you look specifically under Section 2, it provides that coercion is the commission or threat to commit any act forbidden under any law, or the unlawful detaining or threatening to detain any person's property to the prejudice of that person. So you see that the law actually is very authoritative and detailed on what amounts to duress, and it surely defines coercion as such. Then also of interest is Section 13, subsection A of the Contracts Act 2010. It actually provides that the consent of parties to a contract is taken to be free where it's not caused by coercion. Again, the law is saying that the moment there is coercion, then the law will not recognize that contract as one which has free consent of parties. So meaning that coercion or duress actually negatives the aspect of free consent. And as you may remember, under Section 10 of the Contracts Act, there cannot be a valid contract if there is no consent of the parties. Let's also proceed to look at Section 16, subsection 1 of the Contracts Act is also authoritative, and it states in summary that where consent is obtained by coercion, the agreement is voidable. So this section is basically providing for the effect of coercion on a contract, and the effect is to make a contract voidable, meaning that any party who has entered a contract due to coercion can always leave that contract whenever they discover that there was actually coercion. So it is voidable at the option of the person who on whom actually coercion was or undue influence was applied. Let's now proceed to look at an interesting case on duress, and that is the case of Burton versus Armstrong. The citation is 1975, Volume 2, East Africa, page 465. Now, in this case, the brief facts are that a former chairman of a company threatened to kill the current managing director unless he bought his shares. Okay, and of course, they ended up in court, and court held that this amounted to duress, hence the agreement was set aside. So this case is illustrative of the effect, and also it shows you how actually duress can occur in real life. Let's now proceed to look at what doesn't amount to duress. Okay, there are certain situations or there are certain events that may actually not amount to duress, even where on their appearance there is duress, but actually the law does not recognize them as duress. And which ones are those? Where the threats, okay, on a party contracting are actually lawful threats. If someone comes to threaten you, but the threats they are making are lawful, okay, then we cannot say that those threats amounted to duress. The law doesn't recognize that as such. A good example is the scenario in Williams versus Bailey. It's a case of 1886 LR, volume 1 HL, page 200. So basically, in this case, a young man forged his father's sign on a promissory note, which he gave to the bank, causing it loss. The bank approached the father and demanded that the father should mortgage his farm to recover the son's debt, or else, if the father didn't, the bank told the father that it would actually prosecute him. And of course, based on those threats of lawful prosecution of the father then complied to signing the contract. Of course, later on, the father challenged the contract, saying that, no, look, I only signed this contract because the bank subjected me to duress, and as such, this contract is voidable. And court disagreed. Court held that it did not amount to duress, but rather to undue influence. So basically, court was saying that that was undue influence and not duress. I hope you really understand the holding of court. So the point you should take home here is that threats to do lawful action do not actually amount to duress. They only amount to undue influence. So let's now proceed to look at the various forms of duress. The first form is what we call economic duress. And basically, under economic duress, here, entering a contract, this is basically entering a contract due to illegitimate economic pressure. So here what we really mean is that this form of duress applies where a party enters a contract, but simply because they have put on him economic pressure. Okay, there is economic pressure, either pressure or threats emanating from a possible loss or maybe withdrawal of a contract deal or something of the sort, but there must be that economic pressure, and that economic pressure put on the party to enter contract must be illegitimate, meaning that it must be unlawful. Authority for that position, I encourage you to go and look at the case of Atlas Express Limited versus Cafeo Limited. It's a case of 1989, Queen's Bench, page 833, and the brief facts of this case were that Atlas, a national carrier, entered a contract with CAFCO, a small manufacturer of cane goods, to deliver them to Woolworth stores at 1.10 pounds, and that was per carton. Okay, now each load was between 400 to 600 cartons. The loads only amounted to 200, and Atlas refused to carry any more unless CAFCO paid 440 pounds per load. Of course, CAFCO had no immediate alternative and agreed so as to protect its contract with Woolworth. Of course, there was a disagreement and CAFCO failed to pay and Atlas sued. Court held that CAFCO was coerced and had no choice in entering the agreement. So in this case, basically, court went on to discuss, and court actually held that this was a form of duress known as economic duress, and as such, it basically had an implication or an effect on the contract to make it voidable at the option of the party upon whom the duress or the economic duress was applied. Let's now proceed to look at the conditions to be satisfied to establish duress. For a party to go on and argue duress successfully in court, there are conditions that must be proved. So those are the conditions that we're going to be looking at. And of course, these conditions are provided for by the law. I encourage you to look at the case of Occidental Worldwide Investment Corporation versus Gibbs A.A. Savanti. It's a case of 1976, Volume 1, Lloyd's Rip, page 293. Basically, the conditions were as follows. Condition number 1 is pressure was exerted. So you have to prove and show that there was exertion of pressure on one of the contracting parties. And then secondly, the pressure induced the contract. You have to show that that pressure that was exerted induced you into entering, or induced a party into actually entering a contract. Then the third condition is no real choice. Okay, you have to show that actually the claimant had no choice, had no any other choice, but rather to enter the contract. They couldn't have done anything else. And then, of course, lastly, the claimant protested at the time or shortly after the contract was made. So you also have to show that actually there was some sort of protest, okay, that you indicated or you demonstrated your dissatisfaction to the other party as to what they were doing to you, but they could not definitely listen or give you a listening ear. And then lastly, you also have to show that the pressure was actually unlawful. Okay, this is really important. The pressure must be unlawful. If the pressure is lawful, then definitely you will not suffice. This is really important because it negatives the aspect of consent, and we already looked at the position of the law on the aspect of consent under the Contracts Act. I remember us looking at section 13 subsection A of the Contracts Act, which says that if a contract is entered and it is devoid of consent, then the same is not lawful. Also important to note that the victim's silence will not assist the bully. Okay, this is really very important. If the lack of any predictable choice to submit, you see, if the victim keeps quiet or they are silent, okay, the bully or the person who is being applying duress, okay, cannot argue that no, the other party remained silent, and as such it means that they consented. No, that is not a valid argument, at least as per Lord Scammon in Discamal Shipping Company versus ITFW, a case of 1991, volume 4, All England Law Reports, page 871. At least that was the holding of court. Let's now proceed to look at undue influence. We have been looking at duress, but what is the law governing undue influence? This is now what we're going to look at. I encourage you, ladies and gentlemen, to interest yourself in looking at section 14, subsection 1 of the Contracts Act 2010, which actually attempts to define what amounts in law to undue influence. And basically, under that section, it provides that where a person in a relationship is in a position of dominance and uses it to obtain an unfair advantage, that amounts to undue influence. So the moment you are in a position of dominance and you use that position over another party when you're contracting to your advantage, you know, or to obtain an unfair advantage, then in law, that, at least according to section 14 subsection 1, that amounts to undue influence. Let's proceed, ladies and gentlemen, to interest ourselves equally in section 14 subsection 2 of the same act. That's the Contract Act 2010, and that section basically lays down positions of dominance. According to section 14 subsection 2, it is saying that the moment someone is in these following positions, then they are in a position of dominance as to have undue influence, or likely to have undue influence over the parties or a party with whom they contract. And what are these positions? Where the party holds a real or apparent authority over the other party. So the moment you contract with a person and you have that real authority over them, then the law takes it that you're in a position to dominate the will of that other party. And then secondly, the party stands in a fiduciary relationship to the other party. So the moment you're in a fiduciary relationship with the other party, then the law takes it that you're in a position of dominance so as to influence their will. But what does the word fiduciary really mean? These are relationships involving trust, especially with regards to a relationship between a trustee and a beneficiary. So any relationship which involves trust, that is a fiduciary relationship, and that is what that really means. And then also thirdly and lastly, mentally incapacitated persons. This is really important. The mental capacity of the other person or party is temporarily or permanently affected by reason of age, illness, mental or bodily distress. So every time you are with a person or entering a contract with a person who has that, with whom their mental faculties are not in a proper state of mind, then it is taken that you are in a position to dominate them. Let's now quickly proceed to look at the various classes of undue influence. And the first class we are going to look at is what is known as actual undue influence. Now, with actual undue influence here, there is no real relationship. So two parties are contracting, but there is no such real or strong relationship between them. And as such, that is the type or rather class of undue influence. So here, an interesting case to look at is Williams versus Bailey. It's a case of 1866 LR, volume 1 HL, page 200. And basically the brief facts are that a young man forged endorsements on promissory notes and caused a loss on the bank. And of course the bank came for the father, and it asked the father to go on and sign a contract of payment. And of course, this was later on challenged. And we already really looked at the facts of this case. Let's now move on to look at another class of undue influence, and that is what we call presumed undue influence. Now here, with presumed undue influence, there is a relationship of trust. Here, there are two people contracting. There's a relationship of trust between these two parties. Okay, there's a relationship of trust and confidence. And in such a situation, there is a presumption that there is undue influence. So the moment two parties are contracting, there's a relationship of trust and confidence between these two parties. The law will presume, okay, that actually there is undue influence. And of course, that presumption is rebuttable if you adduce satisfactory evidence. Of interest under presumed undue influence, I encourage you to go and look at section 14, subsection 5 of the Contracts Act 2010, which states the relationships of trust to include where there is faith, where there is trust between parties, special relationships of special confidence, or relationships of candor. Candor simply means honesty. So all those, if you're in a position, okay, or if you have a duty involving good faith, or involving trust, or involving special confidence, or involving candor, which we said means honesty, then that is a relationship of trust, and the law will presume that you actually have undue influence over such a person. Now, under this class of undue influence, the claimant need prove only the relationship, and then undue influence is presumed, and it is for the other party to disapprove that in fact there was undue influence. So basically that's how that happens. Let's now proceed to look at another interesting position of the law, and this is section 14 subsection 3, which basically provides that the burden to prove that there wasn't undue influence falls on the dominant party. So it's the dominant party who has to prove that actually there was no undue influence in this contract. Let's now proceed to look at the aspect of proof, proof that the other party was not induced by undue influence. How do you prove? Okay, how do you really prove that the other party was not induced by undue influence? So you will prove by any one of the following. One, you show willful knowledge to contract. You show that actually the other party willfully intended to contract. Okay. Secondly, show that the other party had the benefit of independent, impartial advice before entering the contract. Okay, you go on to show that actually this person who is claiming undue influence, they had independent, impartial advice from an expert who could maybe be a lawyer, or maybe a bank expert, or someone who is experienced in that field. The moment you're able to show this, then it will be, you would have proved that actually the other party was not induced by undue influence. Now, the presumption will also apply in relationships based on spiritual guidance and leadership, parent and child, etc. So here what we are saying is that the presumed undue influence also applies for other relationships, such as parent to child, relationships of spiritual guidance, pastor and his subjects, a reverend and his subjects, those spiritual relationships, a sheikh and his subjects. Also, this presumption of undue influence applies in those types of relationships as well. Of interest to you is the case of Lancashire Loans versus Blacks. It's a case of 1933, volume 1, King's Bench. It's on page 308. And the brief facts of this case are that an extremely domineering simply means bullying or intimidating woman induced her daughter to stand as a guarantor for a loan with a bank. She then defaulted on the loan, and the bank sought to enforce the guarantee against the daughter. The daughter was successful with claiming undue influence. Of course, the daughter went on to say that, look, my mom had undue influence on me. I was simply a daughter. And of course, court accepted that argument. And this case really comes to show the point which I was previously trying to emphasize on relationships of parents and children. The law will also go on to presume undue influence in such types of relationships. Let's now proceed to look at another class of undue influence, and that is what we call relationships of trust and confidence. So every time there is a relationship of trust and confidence, the law will still go on to look at these as a potential area where undue influence is imparted or undue influence is within that type of relationship. So here the types of relationships we're basically looking at are relationships of husband and wife, and also cohabitation is also, actually it also falls within this bracket. So for you who are out there cohabiting, in case you enter a contract and there are issues that could arise, of course the law can presume or take it that actually there was some level of undue influence either by the man or by the woman. So basically, under this type, okay, it's important to note, please note, under this type of undue influence, there is no automatic presumption of undue influence. Please, this is important. There is no automatic presumption of undue influence, but it is accepted that the relationship of parties is one in which undue influence will arise. Okay, very, very important. Under these types of relationships, i.e. relationships of trust and confidence, there is no automatic presumption. The law doesn't automatically presume that there is undue influence, but it is taken, it is accepted that the relationship is one of which undue influence could arise. Okay, this is really important. We already gave those types of relationships. These include relationships of husband and wife. Why is this? Because it was expressly excluded from the traditional cases of presumed undue influence. So this type of undue influence was excluded. So because it was excluded, it's taken that even in such relationships, due to the nature of closeness of the parties, undue influence could arise. Of interest to you, I encourage you to look at a very interesting case of Royal Bank of Scotland versus Eltridge. This is case number 2 of 2001. UKHL, page 44. It's a locus classicus really on this type of class. And basically in this case, a bank took charge of a wife's property, very interesting, as a result of a loan made to a husband to use for his business overdraft. Now, his wife had signed the charge in the presence of her husband after advice by a solicitor appointed by the bank, but whom she argued, the wife argued, that, of course, she later on argued that she regarded as working for her husband. Okay. Now, when the bank sought to enforce the charge, the wife claimed undue influence by the husband and argued that the solicitor had not explained the charge to her on her own, and that the bank was fixed with constructive notice of her husband's undue influence. Now, there's an interesting word here that I really want to throw more light on. That is constructive notice. What does constructive notice mean? In summary, constructive notice means that you ought to have known. Okay? Constructive notice is simply such notice as imputed or implied by law. That's according to Brian A. Garner in the Black Laws Dictionary. That's 5th edition at page 284. At least he defines it as such. But basically, constructive notice, what you should know is that this is a legal maxim, or it's a legal doctrine that signifies that a person or entity should have known, okay, as a reasonable person would have, of a legal action taken or to be taken, even if they have no actual knowledge of it. So basically, constructive notice is a maxim which says that the other party should have known. Okay, they should have known the facts as they are. So basically, those were the facts of that case that you should really have on your fingertips. Also important to note, under this type of under this class of undue influence, is that the party who claims undue influence, okay, if you're to proceed to claim undue influence in court, that party who actually claims undue influence in this class must show that the transactions were manifestly disadvantageous. So you have to go on and show that actually the transactions of this contract were disadvantageous to me. But however, this term of manifestly disadvantageous was changed by the House of Lords in the case of Barclays Bank PC versus O'Brien. This is a case of 1993, volume 4, England Law Reports, page 417. That term of manifestly disadvantageous was changed by the House of Lords to another interesting term, which is transactions accounted for on terms of charity, love, and affection. So basically here, you always have to show, if you're going to proceed on undue influence, you have to show that actually there was that type of effect. Also, finally, please go and look at that case of Barclays Bank PC versus O'Brien. It's authoritative. I already gave you the citation, 1993, volume 4, England Law Reports, page 417. And in that case, basically, the House of Lords laid down very interesting questions and tests which you have to always pose for you to proceed and for court actually to conclude that there was undue influence. And here the first is that, was the wife subject to her husband's undue influence in signing to agree to the charge? You know, especially for such relationships as we have looked at, of relationships of trust and confidence, and where there are, you know, bank transactions. And then secondly, you must also ask that, was the bank put on inquiry of the potential undue influence, and did it act successfully in avoiding being caught by it? Did the bank do anything within its means to ensure that it's not caught up by undue influence? And if the answer is yes, then definitely court will not find that actually the undue influence worked on the other party. Important to note also is that in both the O'Brien and Ettridge cases, court identified that the principle can apply also to cohabitees or others in sexual relationships. Now, if the bank knows of that relationship, it's enough to put it on inquiry. So you're seeing that the House of Lords has gone on to actually stretch this principle to also apply to cohabitees, okay, and also persons who are in a sexual relationship, okay, or in some sort of sexual engagement. So this is really very important to note at this juncture. So ladies and gentlemen, that was all today for our class. Once again, I encourage you to like and subscribe to my channel so that you're always able to get updates. And then also students who are interested in those, you know, private tutorial sessions with experts, you can always contact us and we can make private arrangements for you. Thank you very much. We meet yet again in another class.